This research project compares the way the competition laws of China and Australia apply to bank mergers against financial regulatory frameworks and the dual objectives of competition and economic stability. It seeks to identify lessons for Australian banks and Chinese regulators. The two jurisdictions differ on many issues: ideological approach to the role of the market and the degree of government intervention, the stage of economic development, the nature of banking markets, and the banking regulations. Financial stability is very important to both jurisdictions. The approach of the anti-monopoly law, or AML, is uniquely Chinese. There are no Ministry of Commerce, or MOFCOM, determinations on bank mergers under the AML at this point. The research found that there are a number of examples where MOFCOM conditional merger determinations in other industries diverge from a pure competition-based analysis. The divergences are generally within the terms of the AML, which has objects and provisions containing non-competition factors. Questions remain, however, about how the AML applies to mergers in sensitive industries. The approach by the Australian Competition and Consumer Commission, or ACCC, under the Competition and Consumer Act, is centred on competition analysis. Banking regulation significantly affects both market entry and bank competition. While banking laws and regulations in China mention competition, it is unclear whether any real priority is given to competition in decision-making. Given the importance of banking to stability and national economic development in China, assessment of a bank merger by MOFCOM is very likely to be heavily influenced by factors other than the impact on competition of the merger. Prominent among these factors are the impact of the merger on national economic development and its impact on other competitors. This means that competition assessment alone is unlikely to determine the outcome of a bank merger notification to MOFCOM in China. In short, due to factors such as the historical mix, the inherent nature of banking and the wording of the AML, stability and national economic development will likely trump competition where bank mergers are involved. There is also a distinct tendency in MOFCOM merger decisions to look at the impact of the merger on China in a general sense. A number of implications for bank mergers and lessons for Australian banks arise from the research. Given low thresholds for notification, which MOFCOM has set by regulation, a very large number of merger transactions are notifiable to MOFCOM. Once notified, MOFCOM has jurisdiction to determine whether the transaction lessens competition without recourse to any set threshold of lessening. In Australia, any lessening must be substantial. MOFCOM may determine the issue on grounds linked to national economic development and other non-competition issues and impose conditions. In the context of domestic mergers, the low notification thresholds mean that mergers between SOE banks should be notified, but it's not clear that this is occurring. Mergers between domestic and foreign banks may require notification, but are unlikely to result in anti-competitive impact, given the regulatory constraints on acquisition by foreign banks. Competition issues are unlikely to determine the issue. However, given the history of MOFCOM involvement in sensitive industry mergers, even where shareholdings are low and merger change is small, imposition of conditions on the merger by MOFCOM cannot be ruled out. International mergers between foreign banks which have a presence in China may be subject to notification under the AML, even where the level of business in China is relatively low. This means that conditions may be imposed by the regulator despite little operation in China. Conditions imposed on a merger in any of the above scenarios may be detailed, sweeping and ongoing. This reflects the MOFCOM view that it should be flexible and allow mergers with comprehensive conditions rather than disallow them. The research found that the ACCC decides mergers, including bank mergers, on competition grounds alone. Despite the active consideration of competition by the regulator, however, the market is concentrated and a relatively narrow range of bank competition exists following a number of bank mergers and other developments. Prudential regulators and ultimately the Treasurer may override the ACCC in a determination on a bank merger. Recent independent reviews have made recommendations that competition law must be supported by other competition policy, with the object of increasing competition in banking and financial markets. Lessons from the research for Chinese regulators. Market definition is a tool to assist in predicting outcomes in merger transactions. Australian jurisprudence around market definition generally, and particularly in relation to banking, may prove useful in consideration of mergers in China. Australian market definition tends to focus on smaller geographic areas. Due to the nature of Chinese financial markets, and depending upon the circumstances, bank mergers should be considered against more limited geographic markets. Consideration of a more limited range of products and services may also be useful. Australian jurisprudence around substantial lessening of competition under Section 50 of the Competition and Consumer Act is relevant to interpreting what constitutes an eliminating or restricting of competition under Article 28 of the AML. Australian law has already been applied in the only MOFCOM determination discussing a foreign regulatory determination to date, Coca-Cola Huiwan Juice case, which referred to the ACCC decision in the Coca-Cola berry juice case. The Australian approach, which has been applied to bank mergers on a number of occasions, may prove useful in a banking context in China.